but also they're going to be giving these webinars, so we should be having a few more of these over the year. If you have any subjects that you particularly would like to get a training on, please feel free to email me or Myra. And I want to give these guys as much time as they can to get going, so I'm going to hand it over to Andrea now.
Hi, everybody. This is Andrea Science. Can you hear me okay?
I'm going to say we can hear you fine. If people can just send a message to the chat to let us know if you can hear us. Okay, we got a couple of messages sending us. Great.
Okay. Hi, everybody. Nice to see some of your names again. This is Andrea Science of BDS. I'm a supervising attorney in the NIFA project. And we are going to just jump in here with one of me and Bridget's favorite topics, which is categorical analysis of criminal convictions. And we are sure that there are all kinds of different levels today on the presentation, but we hope this will be a good review for those of you who have done categorical analysis of the state of the case law. We've tried to be as up-to-date as possible and what are kind of some of the hot issues to be looking for. And for those of you who are newer to this, we hope that this will be a good introduction to what are you looking at when your clients are charged with criminal grounds of removability, or you're applying for USCIS benefits for someone with criminal convictions to figure out what grounds of removability and inadmissibility are going to be implicated and what do you do to fight them. So this is the agenda we're going to be looking at today. And I'm going to just jump in with kind of the basic categorical approach and start the modified categorical approach, and then Bridget is going to take us home with some of the more practical and complex issues of exactly how you prove it and what some of the document issues are. Okay. So what we call the categorical approach is a way of figuring out whether our clients have conviction-based criminal grounds of removability. And the reason why we do this is because so many of the grounds in the INA are premised on convictions and not conduct. So, for example, the aggravated felony bar says that your client is convicted of an aggravated felony to be deportable. So what does that mean to be convicted of an aggravated felony? And that's in contrast to some of the fact-based grounds of removability. So if you are someone who's violated the terms of your student visa, or somebody who has engaged in alien smuggling, or someone who has provided material support to a terrorist group, those are fact-based, and you actually just look at what the person did. So we need a way to find out what the client was convicted of as opposed to what they allegedly did or did not do. So this is the way the Supreme Court has looked at this issue, and there is a lot of Supreme Court precedent on the categorical approach. This is one of the rare areas of immigration law that the Supreme Court has come back to again and again in both the criminal sentencing area and the immigration area, and that's because in criminal sentencing, the sentencing judge is trying to find out what did the person previously get convicted of. We're not going to relitigate that. I just want to know what previous convictions there were because that affects the current sentence. Exactly the same as in immigration court, where you need to know what were the previous convictions for because that will trigger certain consequences. We're not going to relitigate it. We just have to find out what they were. So Mathis is the most recent Supreme Court case on this topic. It's very good in the criminal sentencing area, and it describes the categorical approach as finding out whether the elements of the crime of conviction match the elements of, in that case, burglary, and ignoring the particular facts of the case. So we're looking at usually a state statute of conviction, and we're comparing it to a generic offense that's mentioned, in our case, in the Immigration Nationality Act. Okay. So what we call strict categorical analysis or basic categorical analysis, we're going to get to the modified version later, is a three-step process where we identify what is the immigration category that our clients have been charged with or that we're worried that will be triggered by an application. You could call that the generic offense or the removal ground. So what is the category we're afraid of here? Number two is, what are the elements of your client's conviction? So we're often looking at the elements of a state conviction, and we're going to identify what the minimum conduct of that conviction is, because that's what we're going to be comparing. So what's the generic conviction, what's my client's conviction, and step three, is there a match? And that's why we call it the categorical approach, because there has to be a complete or categorical match between those two things to trigger the removal ground. If there's not a complete match because your client's conviction is too overbroad, it contains too many different kinds of criminal conduct, then it doesn't trigger the removal ground right away, and you either win or we get to do more analysis. So let's look at that again, okay? So when we say something is a categorical match, what we mean is that your client's offensive conviction, for example, they have, a drug possession conviction, and that every single version of that conviction is a match to the controlled substance removal ground. The removal ground is, we say, broader than your client's statute of conviction, because your client was convicted of, say, possession of cocaine. There's kind of no way to argue that that cocaine possession conviction does not trigger the controlled substance ground. It is a match, and that means that it will trigger deportability. Okay, this is a classic little picture. And sometimes it's not a match because your client's conviction has some conduct that falls within the removal ground and some conduct that does not fall within the removal ground. So, for example, your client may have a drug conviction, but it doesn't say it's a cocaine conviction, right? It covers all kinds of drugs. Some drugs that are federally controlled and thus are a match for a federal controlled substance offense, and some weird drugs that are only illegal in your state. Those drugs are not a match for the federal ground because they're not illegal to possess on the federal level. So that state offense is not a perfect match. It has some conduct that falls outside the generic definition. So what does that mean? That means that it was possible to commit that crime in a way that is not covered, so we get these two rules that don't match each other, and the conviction does not automatically trigger the immigration penalty. So you might be thinking, okay, but everybody knows that my client actually had cocaine. And again, for the categorical approach, it does not matter. Because what matters is what your client was actually convicted of, not what they actually did. So if you have a client who is convicted under a very broad state drug offense statute where it's not clear which kind of drug they had, or as we're going to talk later, no one has to allocate to a specific drug to actually be convicted. The only thing that we can tell from that conviction is that it was a substance. Then it doesn't matter if your client had 50 pounds of cocaine, because that's not what he was actually convicted of. What he was actually convicted of was simply a controlled substance offense. Okay? So what's important about the categorical approach is that categorical means 100%. So if there's any conduct in the state statute that falls outside the federal removal ground, it's not a match. And that can be really a very powerful tool if you can identify that level of mismatch. It doesn't have to be very big. And that's what the Supreme Court has said. The Supreme Court said in reference to burglary, which was triggering certain federal sentencing consequences, that the state crime, the state burglary offense, had to be the same as the federal definition of burglary or narrower. And if the state burglary offense covered any more conduct than the federal burglary definition, then it's not a burglary for federal sentencing purposes, even if the person actually committed a quote-unquote generic burglary. So the Supreme Court is with us on this, and it's really important to know that. Okay. So this is often what we're doing, is we're looking at the federal removal ground, and we're looking at the state offense to figure out where, if any, is the mismatch, okay? So you can type this in, or you can just play along at home. But The firearms offense, this is a simplified version of the firearms offense in INA 237 A2C, which says owning, carrying, or selling a firearm or destructive device as defined in 8 U.S.C. 921. So this particular example has a cross-reference to a federal statute, and a lot of the removal grounds do, and that's very powerful because then you can say, well, maybe it doesn't match, right, my offense. Okay, so example of statute A is that your client was carrying a firearm as defined in 18 U.S.C. 1921A. Is that a match? The answer is yes. That statute is narrower than our firearms offense, right? Every single conviction under statute A is going to match the firearms offense. So that's a match to your client's detriment, right? Look at statute B. Statute B just says carrying a weapon. Is that a match? Hopefully you're nodding or shaking your head in your office. And the answer is no, that's not a match, right? Because you can carry a lot of weapons that are not firearms or destructive devices as defined in blah, 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 right? That statute is probably very broad, and it can cover a lot of conduct that's not a firearm. Statute C says that the defendant is riding in a car with a firearm. Statute C that you can see on the screen is not a match because riding in a car is not the same thing as owning, carrying, or selling. You could be the passenger and not actually own, carry, or sell a firearm. And statute D, which is carrying a firearm while under the influence of alcohol, is a match because it is much narrower. Even though it has an extra element that you have to be under the influence of alcohol, it still requires you to be carrying a firearm. So that's a narrow statute that it falls within that. So hopefully that's helpful. Okay, that's my picture. So once you have a match, that can be a bad thing, but at least you know what you're working with, right? Okay, a quick note on the burden of proof, which is that just recall that sometimes we have the burden of proof to show that our claims are admissible, whether when they're charged under INA 212 or when we're applying for relief from removal or applying for a USCIS application. And sometimes the government has the burden of proof under 237. And how does this work on a strict legal issue? A lot of times when we're briefing, it doesn't really seem to matter very much, and I would encourage people to argue that when you're analyzing a strict question of law, this burden-shifting framework doesn't quite matter so much because the judge really needs to just figure out the yes or no question, is there a match or not? It doesn't really matter who has the burden of proof. And that's the way that Moncrief, which is a Supreme Court case, kind of deals with this issue. Really, this comes into play more often, and Bridget's going to talk about this more in terms of the record of conviction and who has the burden of production for certain documents. But in terms of the burden of proof, if the government has the burden of proof, then I encourage you to argue that they should brief first, that if it feels like a close question, that means that they have lost. But when we have the burden of proof, I think usually it just feels like the same issue, and I encourage you to remind your adjudicators that this is really a legal analysis more than like a strict corroboration issue. Okay, so the minimum conduct is a really important concept in terms of what does your state statute cover. So to figure out if you have an area of mismatch, you want to kind of find the least thing you can do to get convicted of this crime when you're thinking of measuring it against the federal grounds, what Moncrief calls the least of the acts criminalized, right? So what is the absolute bare minimum that a person could actually do and get convicted of this offense? Okay. So for example, you can think of this. We're going to use some New York examples, excuse us, because that's what we know. New York petty larceny is our classic misdemeanor larceny and theft offense, and all you have to do is steal property. And all you have to do to steal property is, you see our definition there of having intent to deprive another person of property or appropriate yourself to another person. So you can think, what is the least you could possibly do to commit this offense? This is our shoplifting offense. So you can literally shoplift a pack of gum. There's no amount that's required. And you can also do things under this offense where you take something for a while and put it back, like you wear clothes from the store and put them back. So there's pretty minor ways to commit this crime. Similarly, assault in the third is the New York misdemeanor assault statute. It's the lowest level assault, where all you have to do is cause physical injury to someone. You can think, what is the least thing you could possibly do to cause physical injury to someone? You don't have to cause serious injury. You don't have to use a weapon. So in New York, you can literally push someone and they feel pain, right? Or you give them a little mark. So this is kind of your bar fight type scenario. It doesn't require serious injury, hospitalization, anything like that. Right? So if you think of that, you think, what is the least conduct I can think of? And then you think, okay, is that a match? So for both of these examples, both of these crimes are regularly charged as a crime involving moral turpitude. So is shoplifting a pack of gum, is that a crime involving moral turpitude, or is wearing dresses to the gala and putting them back in the store? Is that a crime involving moral turpitude? Is pushing someone in an argument a crime involving moral turpitude, right? When we determine what the minimum conduct is, and Bridget's going to talk more about this, but the Supreme Court says that you can't just use your legal imagination, that you are actually supposed to show some kind of conduct that would actually be prosecuted. So I encourage you to go ahead and start with your crazy law school hypos about how you could get convicted under the statute, but then you may need to go a little bit further and go, okay, has that ever happened? Is that actually covered by the elements of the case law? But I absolutely encourage you to think big when you're trying to identify a mismatch, because as we're going to talk about later, a lot of these arguments that we thought of as creative mismatch arguments have been completely vindicated by the federal courts in the last 10 years, and so this is a very important exercise. For those of you who are fairly new to categorical analysis, I encourage you to look at these cases. If you were to read only these 4 cases, you would basically be up to date on the state of categorical analysis. It's changed a lot in the last 15 years because these issues have gone up and down from the BIA to the circuit courts, back and forth, back and forth. The BIA for a while was maintaining that there were 2 separate kinds of categorical analysis, one for immigration that was a little bit looser and a tighter one for criminal sentencing. And the Supreme Court has made very clear that that is completely wrong. There is only one categorical approach. It is the same for both, and the BIA has had to sort of get its act together repeatedly and kind of walk back some of its prior precedent. So you see Silva-Trevino that I have there, that's actually Silva-Trevino 2. Matter of Chires has been through 4 different decisions, and so those 2 will kind of show you where we are with this, and then Mathis and Mullooly are both very good roundups of the current state of categorical analysis. Okay, so we are going to move on to the next level of complexity here, okay? So we've been talking about a state statute that defines an offense that doesn't match the federal statute, right? But some state statutes seem like they have more than one part to them, right? Or there are a lot of ways that you can commit the crime. So for example, what if your state statute says that it's a crime to possess a knife or a pistol or a ninja star? And that is not a joke. The New York weapons misdemeanor crime does criminalize a Kung Fu star. Does that offense actually define 3 different offenses? And if so, it triggers what we call the modified categorical approach. And what that is that's a way for us to figure out if this state offense actually defines more than one crime. We're going to have to figure out which crime your client was convicted of before we can do our standard mismatch analysis. So it's worth thinking about whether this is good for our clients or bad, or it depends. But what the inquiry is this state statute what we call divisible, meaning it has more than one crime inside of it? And if so, we have to apply what we call a modified categorical approach to figure out which branch of the statute your client was convicted under. So we have to look at some documents that we're going to talk about in more detail in a second, which is the charging document, possibly the plea colloquy, possibly the jury instructions, definitely the certificate of disposition, any verdict form, and figure out what subsection or which elements was your client convicted of. Again, we are still not looking at what your client actually did. And this is really important because some judges and some people at USCIS are very interested in what your client actually did. And, you know, for discretionary purposes, you may not have a leg to stand on that they can't look at that. But when we're only looking at whether your client is removable as charged or whether they have a statutory bar to relief or whether they need a waiver or are eligible for a waiver, we have to stay inside the categorical approach. And so you may need to be the one that's saying, I cannot give you that document, or you can only look at this document for a purpose. You cannot look at it to see what my client allegedly actually did, because that is not what's contained in this document. Right? We recently got a great decision in the Second Circuit, and other circuits have similar decisions explaining that the modified categorical approach allows you to look at certain materials that reveal which of the statute's separate offenses served as the basis for the conviction. That's all we're looking at. Okay, Harbin is a great drug mismatch decision that we got recently. Okay, so what does divisible mean? A divisible statute has elements in the alternative or the disjunctive, meaning it has ors in it potentially. So it's actually containing more than one offense inside of it. And so it's not just a statute that says and or has commas or semicolons, right? It's really important that it's not really about the way the statute is formatted. It's what is the result of that formatting is that part of the statute, but not all of the statute, triggers the removal ground, right? So if you go back here, this statute that I made up here, it has subsections and it has ors in it, but what's really important about this statute is that one of the subsections matches the firearm ground, for example, and the others don't. That's the hallmark of a divisible statute, assuming that the jury would have to find which weapon it was, right? So if you've got part of the statute that triggers the removal ground and part that doesn't, then that's divisible. Again, it doesn't really matter how the statute is formatted. Some states format things really strange in a whole big long sentence. Some have a lot of subsections. What really matters is if those different elements, those different options are actually elements of the crime, or they're just extra details that no one has to actually decide between. Those are called means of commission. So what's important is, does the jury have to find, or does the fact finder have to find those alternative elements beyond a reasonable doubt, or are they just examples of ways that you can commit the crime? Okay. And the reason why this is important is explained in a lot of detail in DeCamp and Mathis, and because every crime has a lot of ways to commit it, right, that the jury wouldn't actually have to decide between. They're just like, you know, fun facts about how this area of the crime went down. And Justice Kagan is really good about this. She explains it in DeCamp, saying that every single crime has a lot of different ways to commit it, and she makes a little clue joke here and says that every crime contains an infinite number of subcrimes. So every crime could have Professor Plum in the ballroom with the candlestick, or Colonel Mustard in the conservatory with a rope. And if we don't stick to the strict version of the categorical approach, if we just say everything is divisible because there are many ways to commit this crime, then it will make everything divisible. It will mean that every single crime becomes divisible, and we have to look at the documents for every single offense, and there would be no such thing as the regular categorical approach. And that can't be right, so we have to pull back from that instinct. Wait, wrong way, sorry. So this is a good time, if I have confused you, if you have any questions you want to write in for us, go ahead. And otherwise, we will forge ahead. Or if you have any issues that come up in your state or your documents, go ahead and we'll get to it as we go.
And Andrea, should we switch over the PowerPoint to Bridget at this point?
If you just give me a couple more slides, yeah, just give me.
Oh, sure, no problem. Just let me know.
Yep. Okay. So this is sort of a thought experiment because many of us are doing removal defense, and some of us may also be doing advising of criminal attorneys on open charges that have immigration consequences, and some of you may do both, or you may do both in your career. So it's kind of interesting to think about this from both sides, right? So you might think, do I want statutes to be divisible? Is that good for my client who's facing removal, who's being charged with a criminal ground of removability, who's being charged with an aggravated felony? Do I want that statute to be divisible or not? And do I want the statute to be divisible when I'm contemplating pleading my client to the statute? You could just think about when you would and would not be making that argument, right? And here is how we think about it usually, which is that usually the ideal is that your client has been convicted of a statute that you can say is overbroad, meaning there's a mismatch, right? It does not match the federal removal ground, and hopefully it's not divisible, meaning you're done. If you show the mismatch and the statute is not divisible, meaning it doesn't have a bunch of alternative elements, then you win without having to produce any more documents, without having to argue about the issue any further. So overbroad and indivisible is the gold standard. If that's not going to happen, if the statute is divisible, and sometimes as you dive into your state case law, you'll see that your statutes are simply divisible. They have multiple offenses in them, or there's already a BIA decision against you on that issue, and there's not much you can do about it in front of the IJ. If it's overbroad and divisible, then you're going to be arguing that the client pleaded guilty to the better portion of the statute. Right, so that happens to us a lot, where subsection 1 is the problem because it has the intent to sell, the intent to injure, whatever it is. The subsections 2 and 3 are better, and we are going to argue, okay, well, the client was convicted of the better subsection for us. Or sometimes you aren't even that lucky, but you're able to argue that it's not clear what part of the statute your client pleaded guilty to. And one of the things that I gave Vera that I think they can post is a couple of examples of briefs that our office has won issues on categorical analysis. Just, you may already have lots of these, but just so you can see an example of what I think is good writing on the categorical approach. And one of those briefs is a case of mine where we argued that it was not clear which subsection the client pleaded guilty to, because he didn't have to allocute to either subsection, and it's not on his certificate of disposition. So therefore, you can't sort of stick him with the bad subsection, because he might have also taken the other subsection, or there was actually no requirement to take one or the other. And that was a winning argument in that case. Okay, so now I'm going to hand it over to Bridget.
Okay, hi everyone. So we're kind of picking up with an example. I think I was introduced at the beginning, but I'll just mention I'm Bridget. I'm a supervisor in NIFUP, and I'm going to pick up with this example, which is our New York assault statute. And, actually, I didn't see any questions come through. I don't know if people need time to type them up, but should we take a little break for that? Corey, I don't know. Because if you do have questions, I can try to address them in the second part, and then we'll also take another break at the end and have time for questions at the end if you want to wait until we've gotten through the whole presentation. So we can take a quick little pause if anybody has anything that you want to make sure that I address.
Okay, and just as a reminder to everybody who's listening, just look on the bottom of your screen. You should see some icons so that you can send questions through the Q&A or the chat, and then you should be able to type those in on the right-hand side of the screen. but send us an email or something if you are having trouble doing that and you want to ask a question.
I'm just going to wait 3 minutes, and then I'll get started again. In the alternative, you can answer the question that's on the slide, which is whether that you think that statute is divisible and why.
Just as a reminder, when you send a chat message or a Q&A message, make sure to select who you're sending it to. And you want to send it so that Bridget can see it. You want to send it to the presenter, but you can send it to the host and presenter, and then we can see it as well.
It's been about 3 minutes, so I guess we'll get started again, but feel free to send questions as we go. We got one response, and it is, I think it's divisible because there are different levels of scienter. So I think the way to start with the divisibility analysis is whether the statute is defined kind of in the disjunctive, so you kind of want to look for ors or different options. The statute is pretty clearly set out in the disjunctive, and there are 3 different subsections separated by or, and each subsection has a different mens rea. So the first is intentional, the second is reckless, and the third is negligence. The second question is, well, are some of these removable? Do some of these fit within the removability ground and do others not? If they all fit within the removability ground, you don't really care whether it's divisible because it's just going to be a removable, the whole thing is going to be removable. And if none of them do, then you also don't really care if it's divisible because then it will be, the entire statute will be not a removable statute. Here we have a situation where intentional assault, the BIA has held in matter of Salon that it is a crime involving moral turpitude, whereas the reckless and the criminal negligent mens reas are not. So then it does fall into the category of a statute that has one subsection that is not one subsection that will trigger the removal ground and 2 that look like they won't. So it looks very much, this looks very much like a divisible statute. It kind of like screams divisible. But that's not enough, and this is something that's really important. This is, in fact, a divisible statute, but you can't just rely on what you see in kind of what meets the eye sometimes, because sometimes there are very good arguments that a statute is not divisible, and for example, the different mens reas are simply means and not elements that doesn't kind of more than meets the eye, that kind of is evident in case law, or in the, if you look at kind of like the broader context or definitional sections of the statute. So, so it's something to watch out for, but this is actually a divisible statute. And we're going to talk a little bit more about how you tell. I think Andrea really set it out nicely about how important divisibility is and how much it can be the difference between winning or losing if you can show that a statute is not divisible, because then what your client did can't be looked at, the record of conviction can't be looked at, and you can kind of argue that the statute is overbroad and indivisible, and it's a really, really powerful tool. So how do we know if something is a mean or an element? An element is just, an element has to be established by a jury and is part of the crime, whereas a mean is just kind of an example of a way you could commit a crime and is not kind of within the definition. It may be in the definition of the crime, but it's not one of the elements that needs to be established beyond a reasonable doubt to convict. So really important here, DHS is the one that has in 237 posture, DHS bears the burden to show removability. They also bear the burden to prove that these different alternatives are elements and not means. So unless your circuit says otherwise, that's the law, and that's really helpful because sometimes DHS isn't very savvy in making these arguments, or you can, you really have to put the burden on them and make sure you're making them make the case as to why it's an element and not a mean, and why the statute is divisible. So the definition of an element, as I said, it's something that has to be like specified from by the prosecutor. It has to be in the indictment or the charging document. And it's something that the jury must be instructed that they have to find beyond a reasonable doubt to convict. So they must, in other words, the jury must entirely agree on the element in order to find a conviction. If there are other facts that, for example, in New York, we have controlled substance offenses that are use the term controlled substance, and controlled substance is the element. The jury need not agree on what the controlled substance is. So some members of the jury may think it's cocaine, other members of the jury may think it was heroin, other members of the jury may think it was something else. It doesn't matter as long as they all agree that all three of those substances were controlled substances, then a conviction is sustained. So that's kind of the difference between what the Supreme Court calls a brute fact and an element. How do you know if something is an element and you have to show it? The jury has to find beyond a reasonable doubt that that it was that particular fact and not something else. It's not always evident, but the first place, I just want to point you guys to Mathis, which is the recent Supreme Court case, which really talks in detail about divisibility and how this analysis works, and it provides some really useful guidance, which actually adopts many of the arguments that we've been making for years about how to distinguish means from elements, and it really makes that distinction and makes it very clear. I know in the Second Circuit, and I'm sure in other circuits, there's a lot of pre-Mathis case law where the circuit courts and the BIA and everybody was like really confused about divisibility and didn't do correct divisibility analysis, didn't look to see whether things were means or elements, and just like, well, it has a list, so it must be divisible. There are various numbers, there are various ors or various commas in this statute, therefore it's divisible. And that's not right, and that's not enough. So I think there's a lot of circuit case law and BIA case law that you have to watch out for that has not been expressly overruled, but you can argue is no longer good law post-Mathis. So it's something to look out for really closely. And what do you look at under Mathis? First, you look to the text of the statute, and that can provide clues. Sometimes it can feel definitive. The second place that you can look is at the penal provisions, and if the statutory alternatives carry different punishments, then they kind of have to be different elements. So if you, like in that assault statute that we looked at previously, if you could be convicted, this is not actually the case, but if it was the case that you could be convicted of a year in jail for intentional assault and only 6 months for reckless assault, that would be a pretty good signal that it's not divisible. Sorry, that it is divisible, that those are two different elements, right? If all the penalties are the same, does that mean it's not, they're not different elements and it's not divisible? Sorry. No, not necessarily, but it could support an argument that these are not elements; they're just means. The third place to look, and this is something that you can also tap into people with criminal defense experience if criminal law is not your area of expertise or knowledge, but state court decisions is the next place to look, and they may just say explicitly, hey, this is something that the jury has to find beyond a reasonable doubt, or actually this is a fact, the jury may not. It doesn't have to be, that you can look at things be creative in the sort of types of state court decisions you tap, like was an indictment, if facts on the indictment are getting changed, is that allowed, is it not allowed, if it's allowed, maybe that indicates that these are just facts and not elements. If it's not allowed, then they might not be. So, you can be creative about state court decisions and see what you can find. Many times they're not totally clear, but this is the kind of hierarchy of sources that you can look at to make your divisibility arguments. And it's helpful to know that it's DHS's burden. So if it's kind of unclear, that's good for you again, because they're the ones that have to prove whether it's a mean or an element. And if they can't prove that it's an element, you, in theory, should win. And Shirez is the BIA case that makes that really clear. So the last thing that you can look at is jury instructions. And jury instructions can often be really helpful just as you're trying to understand the structure of a statute, for your own information. But the case law is pretty clear that you're only actually supposed to look at jury instructions if the other sources are unclear. And even then, only if there are jury instructions in the record of conviction of your actual case. And we'll talk about the record of conviction in a second. But you won't have jury instructions in most of your cases because something like 90% of people plead, and in a case where somebody's taking a guilty plea, probably there were no jury instructions in the record unless your client pled on like the eve of trial or something. So, you'll really only see jury instructions in your record of conviction for your actual case. In the record of conviction if your client has a trial conviction. If there are pattern jury instructions, which, like I said, can be very instructive and very useful. If you feel like they help you in some way, you can use them or put them in. But if you feel like they're inconclusive or they don't help you, remember it's DHS's burden of proof, and you don't have to put them into the record if you don't feel like they help. One thing to watch out for is in pattern jury instructions. They're also not definitive, right? Some pattern jury instructions allow the prosecution to kind of write in or select from their theory of the case, and that will be in the jury instructions because it's something that the jury has to consider. But the jury instructions themselves won't be totally clear about whether the jury has to be unanimous or whatnot. So that just because there's a fact in the pattern jury instructions doesn't necessarily mean that fact is an element and not a means. You still have to kind of look beyond, and the case law is more definitive there. So that's something to watch out for. By that same token, if you look at a certificate of, sometimes there are means, there are facts that end up in various places on the record of conviction depending on how your state court criminal documents are. In New York, we see them often in our certificates of disposition. This was a huge battle that we fought on our controlled substance cases where the certificate of disposition would say cocaine, and so the judge, we would try to argue that the controlled substance ground was overbroad and it was an element and the different substances were means, and the judge couldn't look at the record of conviction to see what substance was implicated in that case, and the judges would look at us and say, are you crazy? It says cocaine right there. But we weren't crazy, and it's true that the judges aren't allowed to look to see anywhere on the certificate of disposition. If the statute's indivisible, they just can't look to see what actually happened. It's a means and not an element, and if the statute's overbroad, it's overbroad, and we won that issue in Harbin at the Second Circuit. So it can be very counterintuitive, and it can be really kind of unappealing to judges, but just because you get looked at like you're crazy sometimes making these types of arguments, they can be very abstract and whatnot, keep making them, because the circuit courts tend to understand this stuff better than the immigration judges. So moving on. So the record of conviction, this is what Andrea was saying, that you're allowed, the judge is allowed to look at for a very limited purpose, right, to determine what crime your client was actually convicted of. So in the assault example that we saw previously, the record of conviction could not be consulted to see who your client punched at the bar, or how bad the injuries were, or, how horrific the things that they said to the victim were. That's not what they can look at. They can only look at which subsection. So they look at the record of conviction to determine, oh, was your client convicted of a reckless assault, an intentional assault, or a criminally negligent assault, and that's it. And once they figure out which one it was, if they can, if it's definitive, then they can't look at anything else. So for example, if the record of conviction shows, the plea minutes show that your client was convicted of reckless assault and the charging document says that it was intentional, it doesn't matter what the charging document says. You're looking to see what the person was convicted of. The record of conviction is defined in two Supreme Court cases, and they're sometimes called the Shepard-Taylor documents, and they include the statutory definition, the charging document, a written plea agreement, if there is one, transcript of a plea colloquy, and then any explicit factual finding by the trial judge to which the defendant assented. So this is like if your client stipulated to the factual basis of a plea, and then in certain instances there are notations or abstracts in a minute order that could be included. And then, like I said, jury instructions, but only in that case, which is really only going to come up in your trial cases, which are, you will have clients convicted at trial, but it's generally uncommon. There are lots of examples of things that are not in the record of conviction, and you can be creative about how you argue these issues, and definitely check the law in your circuit because there are some differences. But here are some examples. It's pretty intuitive, but statements by the prosecutor wouldn't be included, police reports, probation or pre-sentence reports. There's also other admissibility and hearsay issues with those types of documents that we argue about a lot. Statements outside of the plea by your client or by witnesses, and information about a criminal charge absent any information that the charge was pled to. So for example, if you have a completely dismissed charge, that shouldn't be considered at all in the record of conviction. And then information from a co-defendant's case. Reiterating again, just briefly, the record of conviction is only used for the purposes of figuring out what your client was actually convicted of, and there's some nice language in a Second Circuit case that we use a lot that says, it's only for the purpose of figuring out what your client actually and necessarily pleaded to. So the general, kind of more broad point about this is that the immigration judges and DHS just kind of hate the categorical approach because they always want excuses to kind of look at more documents and kind of see what actually happened. And they always feel like they should be able to and are looking for ways to chip away at the categorical approach, and the modified, this kind of expanded modified categorical approach that was in operation for a while was one of those ways, and we just have to keep coming back and explaining that that's not how the categorical approach works. We're not relitigating the underlying offense. Immigration court is not criminal court, and there are a lot of resources go into litigating criminal cases, and we don't do that in immigration court. In fact, they don't even do it in many criminal courts. There's a lot of plea bargains, but in any event, it's a really important point to make, and the Supreme Court keeps telling us again and again and again that we're right, and vindicating the categorical approach, which is really nice to see, because that doesn't happen in every area of immigration law for us these days. So what happens, Andrea mentioned quickly about the inconclusive record of conviction. In the modified categorical approach, the inconclusive record, if the record is inconclusive on deportability and DHS has the burden, we win, right? They can't meet their burden of proof to prove by clear and convincing evidence that the client was convicted of. They can't prove that they were convicted of, the client was convicted of a deportable offense, deportable subsection versus the non-deportable subsection. For example, in the assault statute that we looked at, say nothing in the record of conviction makes clear whether your client was convicted of reckless or intentional assault, and DHS can't prove one way or the other whether it was reckless or intentional, you should win on deportability. It gets a little bit more complicated when we have the burden of proof on to show eligibility for relief, because then we have the burden of production. So if DHS has the burden of production and they don't come up with the plea minutes, and the plea minutes show that that's kind of their problem, right? Like, it's their burden. They haven't come up with the plea minutes. If they need the plea minutes to show it and they haven't come up with it, we win. And you can, you want to be careful about what you put in the record in cases where DHS has the burden of proof, because you want to make sure you hold them to that burden in the modified categorical approach context, and you want to make a record about how much time they've had. They've had, 7 adjournments, and they still haven't submitted any proof of what subsection. Therefore, well, hopefully the judge wouldn't give 7 adjournments, but you want to make a good record about that. But on eligibility for relief, there's a circuit split. The Second, First, and Fifth Circuits, we have good case law that basically says on an inconclusive record, we can still show eligibility for relief, that helps us. And then a few other circuits, there's bad case law on that. I think the Ninth Circuit case law is really complicated, so I had to flag that as an issue for you to look into. I think the Young v. Holder is not a good case. There had been good law before that, but that's something to, if you have that issue, something to make sure you're looking into the up-to-date law at the time you're litigating it, because that issue is in flux. Even in any of our good circuits, you can't create an ambiguity by refusing to put in a document and then benefit from it. So you can't basically say the IJ orders you to file this is where you have the burden, right? So you have the burden of production, and the plea minutes are bad, or you think they might be bad, so you haven't gotten them, and you can't say, oh well, Judge, I'm just not going to produce them, or I can't find them. That doesn't produce the burden. Maybe if you can prove. Maybe you can make a different argument if you can prove, like, the plea minutes have been destroyed and there's no way you can get them or something like that. It's not your fault that you haven't been able to get them, but you can't knowingly put yourself in that situation. And as I kind of alluded to, whenever you're submitting any criminal documents to the IJ, that's a decision that you want to think through really, really, really carefully, because it has implications at a whole bunch of levels. And you might be in a situation where you're submitting documents at bond that could affect removability arguments, and you just want to think really carefully about what you do. And often we don't have a lot of leeway to not submit leeway on discretion. I mean, our judges will often like threaten to take adverse inferences against us for certain documents, you know, complaints and stuff that we don't want to submit. But on the categorical approach, particularly when DHS has the burden, we have a lot of power to refuse to turn over documents that we don't want to turn over. So the realistic probability test. Andrea mentioned before that when we're determining the minimum conduct in the categorical approach, we have our generic statute, right, which might be a statute, a federal statute, because it's referenced in the actual removal ground, or it may be a generic statute that's generic definition that's defined by case law, but either way, we have our generic elements, and we're comparing it to our state statute, and we're looking for our minimum conduct. And sometimes the mismatch is kind of more evident on the face of the statute, and sometimes it requires a little bit more thinking. And what the Supreme Court has said is that for this minimum conduct, it can't just be like a law school hypo that, well, you know, maybe somebody, you know, did this crazy thing, could have done this crazy thing, and that would like technically fall under the definition, even though it seems crazy. You have to show that there's a realistic probability, not a theoretical possibility, that the state would actually apply a statute to conduct that falls outside of the generic definition of the crime. So is it really the minimum conduct, in fact, not just in your imagination? And so how has the Supreme Court or other courts in the BIA said that we can show a realistic probability? Like, what does that mean? And the Supreme Court says, well, first of all, you can show that the statute was applied in that manner in your own case. So in the controlled substance example, you know, you could show that you were actually convicted of possessing this substance that was not federally controlled, or your client was actually convicted. That's not maybe going to happen very often, but it could be possible, so look out for it. Or you can point to other cases in which state courts did, in fact, apply the statute in this non-generic manner. So, hey, I wasn't convicted of possessing this non-federally controlled substance in New York. It's pregnancy hormone for those that are interested. But, you know, hey, look at these people. They were convicted of or prosecuted for possessing pregnancy hormones. So it's not just my legal imagination. This is something that's actually criminalized. The Supreme Court gives an example of this in Moncrief. Moncrief is a case relating to marijuana, but the example, the realistic probability example they give is related to the federal firearms definition, and it has to do with antique firearms. And if your state law doesn't exempt antique firearms, you must show a realistic probability that the state prosecutes them to establish that it's overbroad, right? You can't just like say like maybe somebody could be prosecuted for an antique firearm. I don't know. It looks like that from the statute. You have to show that it's actually done. And so usually we do this by citing to state law, which is really hard sometimes, as you guys know, because criminal cases are often resolved in pleas, and when they're resolved in pleas, there is no written decision, so you don't know what people are being prosecuted for or convicted of. Tricky. Some ways we've gotten around that. Sometimes there's a case, or there's some case law about the statute that's really helpful. We have that in our firearms context in New York. And other times you can attach complaints. You can look at news reports, press releases to show that the state prosecutes a crime under a certain set of facts. So DHS loves the realistic probability approach because it is one of these kind of exceptions to the, not really exceptions, but chips in the categorical approach that allows them to say like, oh, well, it's overbroad, but that's just a crazy scenario and it would never actually happen. So your client's actually deportable for that conviction, because like the vast majority of the conduct is deportable. And so it's appealing, I think, to judges who feel when they see a statute where they're like, well, your client was convicted of possessing cocaine. Really? You're telling me that's not a drug offense? That's just crazy. And the realistic probability is kind of an out for them to say, hey, I told you it's crazy that your client was convicted of possessing cocaine, and any other prosecutions are just, there's no realistic probability that they'll be, that those other substances will be prosecuted, for example. So another thing that DHS argues is that it's not just prosecutions, or not just a realistic probability of prosecution, but that you have to show an actual conviction to show a realistic probability. And they cite to this terrible crime against a child case, crime of child abuse case, matter of Mendez-Osorio, and there's some footnotes in that case that they say shows that realistic probability requires a conviction. I think they're really good arguments that it doesn't, but just something to watch out for. They also say it requires, you can't just show one case, you have to show more than one case. They make this kind of crazy, weird argument that says to show a probability, you have to show greater than 50% that your case was the non-generic conduct, which isn't really based on anything and also doesn't really make any sense. And then in the past, they've made this argument that realistic probability is equivalent to something that we saw in the ACCA and crime of violence context called an ordinary case, which it has to be like the typical case, right? The typical case has to be for the non-generic context. And we have a lot of very good responses to these arguments. One is, well, when you get to the circuit court level, you can argue that there's no deference to the BIA in these, in this analysis. You can also kind of look back to the purpose of the test as defined by the Supreme Court. The whole purpose of the categorical approach is to not do a case-by-case analysis of what actually happened in the case and to save resources, to not be doing these like mini trials of relitigating criminal convictions, whereas all of a sudden if you're relitigating not only your own conviction but like 20 others because you need to prove whether there was actually a conviction, or you need to prove whether you know, the statute actually covered your overbroad conduct by showing an actual case, and you're doing all this research, that's no longer efficient, and it's not really serving the purpose of the categorical approach anymore. And I think it's particularly helpful to point out that there are a lot of pro se respondents, and how are they supposed to research state court case law and get, you know, copies of complaints from defenders' offices to kind of meet this burden of showing a realistic probability. The argument that we've been most successful with in terms of narrowing the realistic probability test is arguing that the realistic probability test simply does not apply where the statutory language explicitly covers the overbroad conduct, because there no legal imagination is required. It's a little bit different if you're imagining up a crazy factual scenario that could, in theory, satisfy the elements. So, for example, if your statute criminalizes the possession of antique firearms, and it says that, and state law, sorry, and the federal definition doesn't, then it's pretty clear that antique firearms are criminalized. You don't need to apply legal imagination to figure out if that's true. Whereas if your state law defines firearms and it's not clear whether firearms include antique firearms or not, and you're imagining that firearms could include antique firearms, then that's a case where you're using your legal imagination to imagine a definition and where you might need like an example or some kind of prosecution to show a realistic probability. So we've had a lot of success. There are favorable decisions saying that where the statutory language explicitly covers the overbroad conduct, there's no realistic probability test in the 11th, 3rd, 9th, 4th, and as of like a few weeks ago, a week ago, also in the Second Circuit. So we've been making this argument for a long time, and this is an example of an argument being made for a long time, and then we're ultimately vindicated in the circuit. I think there's bad case law in the Fifth Circuit. So another argument that we make is a lot of the great recent Supreme Court and circuit case law, you'll have to look at your particular circuit, applying the categorical approach just doesn't apply realistic probability, but doesn't say why. And usually these are cases where the statutory language is explicitly covering the overbroad conduct, and so the implication is that realistic probability doesn't apply if the statutory language explicitly covers the overbroad conduct. And Malooey is one of those cases. Harbin in the Second Circuit is another. In terms of the argument that a conviction is required, you know, if you're dealing with you are dealing with legal imagination, the statutory language doesn't explicitly cover. You can go, one thing you can cite, I think I have the quote here wrong, I don't think it's actually prosecutes. Moncrief uses the language, I think successfully prosecutes, or maybe it's actually, anyway, Moncrief has a helpful language on this issue, and you can argue that a prosecution itself is sufficient and that there's no requirement in the case law for a conviction. And we've recently gotten really good case law on ordinary case, basically holding that it's constitutionally vague, and who the hell knows what an ordinary case is. It's like impossible to figure out and to do that analysis. And so if, hopefully DHS won't be making this argument anymore after DiMaia and Johnson, which are, Johnson was the ACCA case and DiMaia is the, you guys should probably know, the crime of violence immigration case recently from the Supreme Court, but after those two cases, DHS really should not be making that argument anymore. So just a quick note on exceptions. These are removal grounds and bars that are not categorical. So the categorical approach doesn't apply. There are certain aspects of certain aggravated felony grounds. For example, the fraud aggravated felony ground has an amount of loss requirement of $10,000. And in Nijwan v. Holder, the Supreme Court held that that's actually a circumstance-specific analysis, and the categorical approach doesn't apply. So that's something to watch out for, and the same thing for bail jumping aggravated felonies. Another circumstance-specific analysis which comes up is the single scheme exception to the 2CIMT ground, which kind of makes sense because you're dealing with two crimes in order to make out that ground. In my experience, in my practice, that ground doesn't come up, that argument doesn't come up all too often. It's usually pretty clear when something is a single scheme or not, but you know, it can come up, so it's something to watch out for.
Because the case law is terrible now and nothing is a single scheme anymore.
Right.
That's why fact-based grounds are bad. Okay, go ahead.
But continue to make the arguments. The 30-gram personal use exception for marijuana, the domestic nature of a CODV offense, and also particularly serious crimes, which are bars to asylum and withholding of removal. Those are very fact-based analysis. It's a very fact-based analysis, and the factors are in matter of Frantescu. And then, as Andrea mentioned, any non-conviction-based removal or inadmissibility ground. And one example that we've been seeing come up more and more often in New York, once we've been winning a lot of these controlled substance arguments, is the reason to believe drug trafficker ground is also fact-specific. All right, so I think we have some time for questions. I haven't gotten any, but in terms of, I just want to say kind of generally that the categorical approach can be kind of intimidating and abstract, and the more time you spend with the cases and the more time you spend kind of working through the analysis yourself, the the better you'll get at it. It's kind of like a muscle that, like, if you exercise it, it'll start to be easier and start to come more second nature. But there's a lot of really great resources out there, and so don't hesitate to access them. And that's certainly what I did when I was kind of starting out in this practice, and would read some of this categorical approach case law, and my eyes would glaze over, and I would think, oh my God, wait, what? Overbroad? Is that broad? Is this broad? And really taking the time to kind of walk through the analysis yourself. I know there's some really great, some of your states may have the, what are they? The charts that say, oh, is this removable or not removable? That can be, fine as a secondary resource or as a quick consult to give a sense, but it's really not sufficient, because those are not, the case law's changed immensely. It's changing really fast, and you also really need to understand, sometimes there are creative arguments that you can make and that you can preserve and that are really to the benefit of your clients to preserve, that are not going to be referenced in those guides, and you can really push, as defenders in court, you can really push the bar forward on these arguments, and that's really exciting and fun. So the resources I want to point out is we obviously have our Safe Cities. This is a plug for our technical assistance. You can email the 2 emails on the slide to set up a consult with me, Andrea, and a couple of other awesome attorneys at our office for more case-specific stuff. There's also really great resources at the Immigrant Defense Project. If you guys are not familiar, they do a ton of impact litigation and consulting on these issues, and they're the folks. They have a hotline. They have millions of advisories and trainings and books, and same with for those folks that are out in the Ninth Circuit. ILRC is fantastic as well. If you're kind of wrapping your head around this for the first time, you might want to get a copy of Mary Kramer's book for your office. And then the other thing that I'll recommend is, we have the luxury of being embedded in a public defense office where we kind of have and actually all 3 NIFIP providers in New York are, where we have the ability to kind of walk down the hall and talk to our criminal colleagues and say, like, hey, I'm looking at this statute, I really don't understand it, or where is the definitional provision, or what are the penal, what are the different penal provisions? How does that, how does sentencing for this crime work, or what's the burden of proof, or, can you help me understand the jury instructions? So those are all questions that we can ask in-house, or for realistic probability, we can, find case examples in-house, for example. So for those of you who are in criminal defense organizations, if any of you are, and I'm not sure, use that resource, use your colleagues, and for those of you that are not, I really encourage you to develop relationships with your local PD offices. You'll probably share clients anyway, so those are good opportunities to open the lines of communication and have these conversations with them, point you to good case law. What's funny is sometimes what's good case law for you in the categorical approach is bad for them. So that's always good to find good news for somebody, even if it's bad for somebody else, because we like it when really ridiculous things are prosecuted. And so if there's a case sustaining a conviction for something really dumb sounding, that often helps us, even though it doesn't, like, our criminal defense colleagues don't like it. And the same is plugging into your, there's usually in each area, there might be some Crim practitioners who really delved into or started to delve in, or maybe not, maybe you guys are just kind of starting the charge to the Crim issues in your area, and you should find out who those people are and tap them. We do that all the time here with IDP, and many people who have worked for IDP and moved on, and it's a really robust community in New York, and I think that's helped us to kind of push a lot of these issues forward. So that's all I have. Andrea, did you want to add anything to the where to go from here slide?
I don't think so. I think that pretty much covers it. I think, as Bridget was saying, the best way to do this this area is just to get practiced at it, so we're happy to give you any sample resources we have. Obviously, things involving your state convictions are going to be state-specific, but I feel like part of this is the exercise of analysis and practicing and analyzing convictions, and then the rest of it often ends up being more of a briefing exercise, and if that's something that we can help support you with, we would love to do that. Or you can find out who's really good at briefing in your office or your state and look at how they do things as well. So yeah, we're here to support.
Yeah, I totally agree. And also just don't be intimidated. Like, I think that it's very easy to look at it, and DHS, you can get a bunch of documents in court, or you look at a conviction and you're like, oh, like, that really looks like a rape ag fell. Like, oh, he committed rape. Like, that's what it says. Or, you know, he was convicted of possessing cocaine. Like, okay, I guess we're out of luck. Like, it's really easy and tempting to feel like you have to do that. And the whole point of the categorical approach is that's not enough. And to not let those snap judgments kind of cloud your analysis, and remember that every single statute, you have to go back to the statute, you have to go back to all the weird definitional provisions that might be behind there, helping you look at the state case law, figure out if you're not sure whether the statute's divisible. Is it divisible? Are there non-deportable subsections that could potentially help you? Is there some weird overbroadness? You know, the state schedules for controlled substances in New York are not obvious. You would not obviously find that. You really have to kind of dig. But I think we've found that the more you dig and kind of take advantage of the different resources that are out there in terms of brainstorming these arguments, I do want to say there's great recent Supreme Court case on sex offenses. So the case law on sex offenses, there's many, many New York sex offenses that we've been getting termination on, not intuitively. And so just the categorical approach is not intuitive. And so if you're not sure you're understanding, ask for help, because there may be arguments there that you're not seeing. There may not be, but you know, it's something to go through really carefully and really step by step. I am seeing 2 questions in the Q&A, Andrea, but I actually can't seem to read them. Are you able to?
No. Oh.
If you can't see them, we can read them to you if that's helpful.
That would be great.
Okay. The first one, is that the first one?
Yes.
It says, sorry if you already covered it. Can you give us an idea of what the record of conviction usually consists of? That's question number 1.
Yes, we already considered it. We already covered it, and I'll tell you the slide number in a second. Do you want to read the second question? I'm just going to scroll back to that slide.
Oh, sure. Okay. And then the second question is, from a practical point, do you see that judges permit respondents to replead to NTA to replead to the NTA when they had been pro se or when they had been rep?
So in my experience, I've had really, I think it's probably judge specific, but in my experience, I've had very good luck with this. I've done motions to replead, like when I've taken over a pro se case, or when like prior counsel had no idea what they were doing and conceded something. It's obviously a lot easier. The posture that you want to be in is doing a motion to reconsider if something was sustained and a legal argument wasn't made, and hopefully the ground was initially denied. That's a much better posture. It's why we usually deny criminal charges of removability, because there are all sorts of weird arguments out there, and you never ever know. You know, now having done this for the number of years that I've done this, the arguments that I thought were like total, like not going anywhere, that have ultimately been successful, it shocks me, honestly. So you do want to make the out there arguments, but in terms of motions to replead, I've had really good luck, and so I say go for it. And if it doesn't work, you make your record, and you make your record of the argument, and hopefully you can take it up.
I think this is also an issue where your presence in the courtroom may end up changing the culture, and if you're lucky enough to be in a jurisdiction where you have an open line of communication as a stakeholder about your program, that you may end up sort of being able to move some of your judges to not take pleadings on complex charges of removability from someone who's pro se, because I feel like at least some judges understand that maybe if you're going to give a continuance for counsel, you do not have to make a pro se person plead to an ag fel charge. Early in my career, I represented somebody who had, admitted to a 2CIMT charge pro se when he did not even have a conviction. One of them was not a conviction for immigration purposes. It was really appalling, and I'm sure some of you have seen some of that. So I would think of it both in terms of like, yes, you should go ahead and move to withdraw the pleadings or redo the pleadings to preserve that issue, call it a miscarriage of justice, or in the Second Circuit, there's some case law saying that, like, in the interest of justice, the judge can, in their discretion, allow you to withdraw the pleadings, but maybe also as an administrative advocacy tool if you think there's room to have your judges not take pleadings from people.
Absolutely. It looks like there's a third question, but I can't see it.
Yes, the third question is, what is the recent Supreme Court sex offense case that you referenced?
Oh, it's my favorite case. I'm so happy to talk about it. It's called Esquivel-Quintana, and it's basically about statutory rape. So it's not going to affect cases that are not kind of statutory offenses that are based on the age of the victim, but for cases that the conviction or there are statutes where there is some element that the age of the victim is included, it basically restricts the definition of a sexual abuse of a minor conviction, and I think it's very easy to extend that to the rape context as well. There's a horrible BIA case called Matter of Keeley, which hopefully will get overturned at some point, that kind of expands the definition of rape, or actually initially clarifies the definition of rape after Esquivel-Quintana. I think it was kind of a response to it, but that's something to watch out for. But it's a great case, and it favorably affects many of the statutory sex offenses in New York.
Yeah, I think it's a really important case. I think even beyond the issue of if your state has sex offenses that involve, like, certain age disparities, because I think it goes to a broader issue that the BIA has done a very, very bad job of defining what sex offenses have immigration consequences, because they've preferred to sort of say that they're icky and bad, which is not very analytically rigorous. And so the Supreme Court has finally kind of called them on that and said, you don't have any definition, it doesn't make sense. So we have a Second Circuit case right now that we're going to be litigating that's based on Esquivel-Quintana that sort of deals with the mens rea issues and the fact that any BIA decision that relied on this sort of like quasi-definition that the BIA put forward before in Matter of Rodriguez is no good. So I think it opens up a lot for your clients who have these low-level sex offenses that people think are sort of quote-unquote icky. They actually cover really, really broad, minor conduct and shouldn't be removable.
Mm-hmm.
Cool. And then, Bridget, did you answer the question about the record of conviction? Oh, yeah, that's the slide.
I put it back to the slide, so I'm not going to repeat the slide, and then the next slide after that is some examples of things that are not in the record of conviction. But obviously, research your individual circuit case law. But those are the basics.
Okay, I think we're just about out of time, and I don't see any other questions. So I just want to thank you, Bridget and Andrea, so much for doing this presentation for us. And thank you, everybody, for participating. And please email us if you have any other ideas for trainings or follow-up thoughts or questions. Definitely reach out to Andrea and Bridget. Thank you, everyone. Oh, we'll be posting all of this to be available to you soon, and we'll let you know once it's all available. Thank you.
Thank you.